The broadcast is now starting. All attendees are in listen-only mode.
Hello and welcome to AWCI's online learning series. Today's presentation is Preventing and Responding to Workplace Violence. My name is Town Nguyen, AWCI's Learn Education Program Manager. So before we get started, a few housekeeping items. Number one, all attendees should be on mute during today's presentation. And two, should you have any questions at any time during the broadcast, please submit it using the question box in your GoToWebinar dashboard. We will have a brief Q&A at the end of our presentation. So without any further delay, it is my pleasure to introduce our three presenters. First, I would like to introduce Kara Marcial. She is a founding partner of Con Marcial Carey LLP and chair of the firm's National Labor and Employment Practice Group. She focuses her practice on representing employers in all aspects of the employment relationship. In March of 2020, Ms. Marcial started her firm's COVID-19 task force, on which she advises employers on the employment law and workplace safety implications of COVID-19. Next is Lindsay A. DeSalville, who is also a partner at Con Marcial Carey LLP. She represents employers in inspections, investigations, and enforcement actions involving OSHA, the Chemical Safety Board, MSHA, EPA, and state and local safety-related agency. She also handles all aspects of OSHA's litigation, from criminal prosecutions to appeals of citations. And last but not least is Terry Patterson. She is a principal at Control Risk and a retired career executive and a special agent with the FBI. She has over 2 decades of experience in operational readiness, strategic program development, and critical incident preparedness. Her specialty is threat management with an emphasis on workplace violence prevention and intervention. So with all that, welcome, ladies.
Thank you. Thanks, everybody, for inviting us to present this really important and timely topic, and something that has been affecting workplaces for many years, but in particular, we've seen quite a few in this last few months. Our agenda today is pretty straightforward. Lindsay's going to start out. She's going to talk about a little bit just broadly what is workplace violence, and then discuss sort of the OSHA implications of workplace violence and what the federal agency is doing to address workplace violence from a federal regulatory perspective. I will then cover the employment aspects of workplace violence and things that employers should consider, policies and procedures and other aspects of potential liability that workplace violence issues and incidents can create for employers. And Terry's going to close out with some recommendations and strategies that she has seen in terms of putting, protocols and plans in place, and how she has worked with companies to prevent workplace violence from happening. And then hopefully we will have about some time at the end to answer some questions. So please don't hesitate to pop in some questions into the chat function, and we'll make ourselves available at the end of the presentation to answer those as they come up. And with that, I'll turn it over to Lindsay.
All right, thanks, Kara. So before we hop into our discussion on the implications in OSHA and employment law, we first wanted to give a little context for the issue. So what is workplace violence? And OSHA actually provides a definition for workplace violence. But before I kind of delve into that, I think when a lot of us hear workplace violence, we think about the newsworthy incidents that we've heard about. Even within the last year, there's been multiple high-profile incidents, and those are usually sort of active shooter situations. But workplace violence is a lot broader than that. Workplace violence, per OSHA's definition, is any act or threat of physical violence, harassment, intimidation, or other threatening, disruptive behavior that occurs at the workplace. And just to pull a couple of things from that definition, you'll note that although, again, what we often think of is an active shooter situation or, generally more physical violence, workplace violence does include more than that. It includes harassing behavior, intimidation, bullying. If an employee receives a threat from a customer or a coworker, those are all considered instances of workplace violence. And from an OSHA perspective, as well as from an employment perspective, it's important to have that broad understanding to really ensure that all the different types of workplace violence are addressed in your work environment. And then the second piece that I wanted to highlight here is what the workplace is. So I think, when we think of a workplace, we think of sort of the four walls of the facility that someone works in, the office building, but the workplace includes more than that. It includes anywhere that an employee is present for work-related activities. So if you have employees that travel, a lot of employers now have remote employees. You have employees that maybe travel to customer or client sites. So if a workplace violence incident were to occur at one of those locations, that's still considered workplace violence because the incident occurred where an employee was performing work-related activities. So in addition to a definition for workplace violence, we wanted to talk a little bit about who can actually perpetrate an instance of workplace violence. So there's sort of three main categories that we think about. The first is employees, and that includes not only current employees, but former employees, or even potentially a rejected job applicant who may come back to the site and some workplace violence incident might occur. Oftentimes, we see that the employee or former employee may have made a complaint, or they feel disgruntled toward the employer for some reason. But there are also instances where an employee or former employee may commit workplace violence without a specific complaint or really something that would have prompted it. The second main category is known third parties. And you'll see there's a chart on this slide as well that sort of shows some statistics around each of these kind of groups. Known third parties are, partners, spouses, family members that might come to the workplace and commit an act of workplace violence. A big category under this header is clients and customers, or in the context of the healthcare industry, patients. And then finally, the last category is strangers. And you'll see statistically that strangers are the biggest perpetrators of non-fatal workplace violence incidents. And strangers include mainly those that might come to the site with criminal intent. So in the context of a late night retail store, for instance, like a late night gas station that's open, into the early morning hours, that can be a place where it is more likely that someone might go to commit a robbery. And so that would be a stranger committing an instance of workplace violence. There are also, this category also includes sort of random incidents that occur where there's no sort of direct or obvious criminal intent or connection between the perpetrator and the particular workplace. And then you'll see, looking at the chart, that there is sort of a final category here, which is categorized as unknown. And this is just, the workplace violence incidents that occur where it's not clear what the relationship is between the victim of the workplace violence, if any, and the person who actually committed the act of workplace violence. And then just some statistics to provide additional context of how prevalent this issue is. So in 2020, according to the Bureau of Labor Statistics, which is the federal government agency that collects data on workplace injuries and illnesses, about 20,050 non-fatal occupational injuries occur due to intentional injury by another person. So this doesn't necessarily include those instances of workplace violence that are threats or harassing behavior without physical violence or bullying without physical violence. These all relate directly to injuries that occur to a person, and specifically recordable injuries, injuries that would be included on an OSHA log. So it doesn't necessarily include all of the instances of workplace violence, and we actually think that that would probably be a much larger number. But this at least gives you some idea of how prevalent it is that employees experience injuries related to instances of workplace violence. Of those injuries, the vast majority occur in the service providing industry, and specifically about 80% of them occurred in the education and health services industry. Some other statistics related to fatalities. In 2020, there were about 4,764 workplace fatalities, and about 14% of those were from intentional injury by another person, and about 8% were actually considered workplace homicides. And finally, about 25% of workplace fatalities occur among women workers. So one sort of broad topic that we did want to just touch base on before going into the specific discussion here is just, again, talking about why this issue is important and providing some additional context around that. So just in 2022, we have had multiple, significant instances of workplace violence, several active shooter incidents, as well as some physical assaults. So in most recently, we just had one, earlier this month, I think just a week ago. So this is definitely an issue that is still really important now, potentially more important than ever for employers to be aware of this issue and sort of how to effectively address it in their own work environment. And then the last bullet point just sort of shows, OSHA does enforce this issue. If a complaint of workplace violence comes to OSHA, they might go to a site and inspect, and I'll talk a little bit about that in the next few slides, but it could be a significant enforcement action. We don't often see fines in the hundreds of thousands of dollars related to a workplace violence incident, but that can certainly occur and did at this particular psychiatric treatment center. So now I will address how OSHA enforces issues of workplace violence and the expectations that they set for employers. So as many of you might know, workplace violence is not actually something that is regulated by OSHA through a specific standard. There's no standard in the regulations that OSHA is charged with enforcing that lays out what workplace violence is or how it should be addressed in the work environment. But OSHA still does have enforcement actions that occur related to workplace violence. And they do that using what's called the General Duty Clause, which is Section 5A1 of the Occupational Safety and Health Act. And that provision of the act is very general. And all it says is that employers have to provide employment and a place of employment that are free from recognized hazards that are causing or likely to cause death or serious physical harm. So really broad standard. And if OSHA wants to bring an enforcement action against an employer related to workplace violence, there are 4 specific elements that they would have to establish to show a violation of the General Duty Clause. The first is that the employer failed to keep the workplace free of recognized of hazards. The second element is that the hazard is recognized either by the employer or in the industry. The third is that the hazard was likely to cause serious injury or death. And then the fourth is that there is a feasible means of abatement, so that there are ways out there, there are safeguards that the employer could implement that would lessen the threat of workplace violence or potentially prevent workplace violence altogether. Particular element that we wanted to just focus a little bit of time on today, because it is the one that tends to be a little harder sometimes for OSHA to prove, but also is important for employers to be aware of, is this idea of the hazard being recognized. And I mentioned already that there are sort of 2 main ways that the hazard can be recognized, and that is either because the industry recognizes the hazard. So for instance, the healthcare industry certainly recognizes the hazard of workplace violence, or if the employer specifically recognizes that workplace violence is an issue based on its own experiences. And so what OSHA will rely on to establish a recognized hazard are the types of guidance and data shown here. So industry consensus guidance, if your particular industry has addressed the issue of workplace violence and established some standards or guidance for how to address that in your workplace, that could be something that OSHA relies on to prove that hazard is recognized. The employer's own policies, if the employer implements a specific workplace violence policy, I don't think OSHA generally doesn't solely rely on that, but that could be a way for OSHA to say, you know, look, you would recognize this hazard, that's why you have this policy. The employer's injury and illness data, employers generally have to keep OSHA 300 logs where they record certain types of injuries and illnesses. And if OSHA sees repeated instances of workplace violence on that log, then that could be a basis to say that it should have been a recognized hazard in the work environment. And then finally, OSHA will often rely on its own guidance. So they have developed guidance for specific industries and standards for those industries. OSHA also has basic guidance out there that could apply really to any employer about how to address workplace violence. So OSHA could certainly rely on those documents, particularly the ones they have for specific industry, where there might be some data to show that this is a recognized hazard. And then, you know, OSHA, like I said, certainly relies on their guidance when they are conducting workplace violence investigations and when they move forward with an enforcement action. Because there's no standard, the guidance is really what they use to establish what, you know, they would expect to see in the work environment. And then this just goes into a little bit more detail on the industries that have specific guidance from OSHA. The three main industries are taxi drivers, healthcare and social service industry, and late night retail establishments. So OSHA has specific guidance for all those industries. But I do want to emphasize that even if OSHA does not have guidance for a specific industry, again, they have general guidance for workplace violence and how employers can effectively address workplace violence. So even for a specific employer that is not in any of these industries, if OSHA can still establish that workplace violence would have been a recognized hazard in that particular establishment or for that employer, then they could certainly still issue a general duty clause if you know, there is evidence to establish that workplace violence is a hazard for that employer. So outside of OSHA and their enforcement ability, there is an effort to have OSHA pass a workplace violence rule so that there would actually be a regulation in place by which OSHA would enforce issues of workplace violence in the work environment. It is kind of stalled at this point. The effort started back in July 2016, and there's been initial information collected related to putting together a proposed rule. But per the current regulatory agenda, it's still at the pre-rule stage, and a lot of steps need to be taken before a rule could actually be passed. But this has definitely been established as a priority for this administration. So we'll see if it makes any progress during this administration, but it is an ongoing effort. In addition, there is a workplace violence rule in Congress. Again, has not really made much progress, and what the rule would really require that Congress is considering is just that it would require OSHA to pass interim final rule on workplace violence, specifically for healthcare and social service workers. So again, this law was just proposed again in 2021, but it was proposed in prior congressional sessions and has not really made any progress, but this is something that is out there as well. So with that, I will turn it over to Kara to cover the employment law implications.
Thanks, Lindsay. So with employment law, as an employer, you've got to think about how workplace violence can impact your workplace, and in particular, what potential liability could be out there. And what we see is we see liability stem from three really different types of areas. First is from the employees and third parties. You know, to those employees, if you've got someone coming in, as we just saw, last week in Chesapeake, Virginia, an employee working overnight and has an active shooter situation, and you've got both employees that die, but you also have other coworkers that were involved in so you have liability to them. So as Lindsay just talked about, one of the largest areas of liability can be under the OSHA Act General Duty Clause. You know, if there is a workplace fatality, OSHA will come in and do an investigation, and they will determine whether it's something that should have been prevented under the general duty clause. And as Lindsay highlighted, in at least one situation, OSHA issued, a several $100,000 fine. So that's a potential area of exposure. You also have exposure to the extent that you knew or should have known that the perpetrator of the violence, whether it's an employee or someone else, that they had a background or was otherwise exhibiting certain behaviors that seemed odd, and therefore you were not properly supervising them. So that can come first at the hiring stage. And many employers implement background checks for this very reason. And depending on the nature of the job, how they interact with others within the job, they will perform a variety of different background checks. Many states, I will caveat this, a lot of states right now have passed laws preventing employers from doing background checks, criminal background checks included, until after an offer of employment is done. And so once you get a conditional offer of employment, employers can run those background checks and look to see if they have any history of violence or any other criminal history that could negatively impact their job duties. And so one area is if you didn't do a background check on somebody that you probably should have, or you did do a background check and you didn't catch something that could be an issue. So there's a civil claim for negligent hiring in that circumstance. Even if you did a background check and it came back clean and there were no issues, as an employee works and goes through their employment, there could be issues that arise where their behavior seems off. They make uncomfortable comments to other people. They raise issues of concern. And if other employees hear those concerns and make complaints, or if supervisors hear those concerns and don't address them with the employee, there could be a potential claim for negligent supervision, negligent retention. We actually are seeing that play out right now in Chesapeake, Virginia. A civil lawsuit has already been filed against Walmart by an employee who was impacted by the shooting last week, and has filed claims both on negligent hiring and negligent supervision because she claims that she had raised complaints about things that the employee had said to her, the things that she had noticed before, and that Walmart did not take adequate measures in supervising and addressing those odd complaints, including asking whether she had participated and whether others had participated in active shooter training. So there were just some things that she believes raised some suspicious behavior. And I think Terry's going to talk a little bit about this, about ways that you can create a plan when you have coworkers or supervisors that may be observing those types of issues from their coworkers. You also potentially could have liability to the individual employee victim. If you've got someone who is the victim of a workplace violence issue, often even harassment, we'll talk about that in a few minutes. Your obligation to maintain a harassment-free workplace. A lot of these may not be a shooter situation, but it may be creating an uncomfortable verbal workplace situation, verbal harassment, even physical harassment, physical assault. That all stems under the harassment-free workplace. Potentially FMLA, if someone is experiencing issues in the workplace and they need to take leave to address those issues, whether you need to have an obligation under the federal or a state equivalent paid leave law to provide for leave to an employee who may be experiencing a health issue or some other issue as a result of behaviors that they're experiencing in the workplace. And then third, there's retaliation and whistleblowing. Again, if someone brings a complaint about concerns that they're seeing in the workplace or things that are happening to them, and some action is taken against them, they could view that as you're terminating me, or you're disciplining me, or you're taking action against me, not because of a legitimate business reason, but because I raised this concern about my coworker or about something that's happening in the workplace. And then third, there's also the individual to the employee, the potential person who is being accused of this behavior, right? So you could investigate and determine that it's appropriate to separate that employee from employment. That individual could have a claim for wrongful termination if it's a he said, she said, if the investigation isn't investigated thoroughly, properly, if there's some other basis for the termination. the employee could raise a claim against the employer for wrongful termination or some other type of discrimination or accommodation under the ADA, particularly if the individual who is the perpetrator has a mental health crisis, right? So you've got to think about what could be an issue if someone is making strange comments, potentially making veiled threats. You ask them to leave the workplace, ask them maybe, you go to your EAP provider, I think you need to get some help. That person is in crisis, that person then takes leave. You've got to determine whether you need to potentially put them on FMLA leave if their leave qualifies for that, or if their leave qualifies as a disability under the Americans with Disabilities Act. So you want to be very forthright while protecting your workplace and having someone maybe leave the workplace if they're engaging in this behavior. You also want to determine whether you have any legal obligations to that individual, again, either under the FMLA, ADA, or some other paid leave law or unpaid leave law for them to be able to get treatment for their crisis. You also potentially, again, be sure engaging in privacy issues. You don't want to be sharing information with others within the workplace that don't have a need to know it with respect to the manner and the behaviors of other employees. And then finally, again, defamation could be a potential liability depending on what you say to third parties or others about the behavior or the conduct or comments of an individual. But so there's a lot of different potential scopes of liability that an employer can face in these types of situations, and it's really important to be mindful of each of them, and that each person, both the victim and potentially the perpetrator, could have some protections that you want to think through as you're navigating these challenging issues in the workplace. So, harassment, EEOC issues, this type of behavior, unwelcome conduct, really has a significant impact on employers. Just looking at, charges that are filed with the EEOC, that's the Equal Employment Opportunity Commission, that's the federal agency that investigates and reviews claims of discrimination, harassment in the workplace, whether it's sexual harassment or disability harassment, race harassment, a variety of different things. So we see just last year, fiscal year 2021, we saw over 21,000 charges alleging just harassment with the EEOC. Of those, about a little over 5,000 were based on sexual harassment, which was a little less than 10,000. 10% of all charges filed allege some type of sexual harassment. So we know sexual harassment is unwelcome conduct. It can be verbal, it can be physical, and it's based on somebody's sex. Last year, the EEOC filed 71 lawsuits under Title VII, which includes not only sexual harassment, but other harassment claims as well, which is a significant number. That's because they investigated it. They were unable to resolve the claim. They believed that the employer had reasonable cause to engage in harassing behavior, and they should have taken steps to prevent it. And as a result, they proceeded to court. Also, they also spent, when they don't go to a lawsuit or through an investigative charge, they also try and really resolve these types of charges. And they do that by recovery of fines and penalties, payments to the complaining party, and other monetary remedies. And so last year they recovered over $60 million for complainants related to claims of sexual harassment, again, through either litigation or through administrative enforcement. So there's, that's a significant, financial consequence for employers, making sure that not only do you have a financial penalty to a complainant, but also the time and resources that an employer would spend in investigating, defending, and ultimately trying to resolve any claim of harassment or discrimination in the workplace. In 2016, the EEOC had a select task force finding, and which talked about harassment in the workplace. And that's another reason why this is still a really prominent issue that we're seeing in 2022. That workplace harassment remains a persistent problem that is often goes unreported. People are reticent about filing a complaint, either internally or formally with the EEOC for a myriad of reasons, largely because they're afraid of retaliation, or they're afraid that maybe the company won't do anything about it, or because they don't want to be caught in the middle of what arguably could be a sensitive or personally sensitive issue. They might be embarrassed. And so there's a lot of reasons why things don't get reported, which is why it's really important that employers have strong policies and procedures to be proactive in addressing harassment before it needs to be reported, either formally or internally. And so there's a really strong, compelling business case for stopping and preventing harassment that the task force found. It's no surprise that harassment can cause pain and suffering to the victims as they experience mental, physical, and economic harm. And that's one of the reasons we're still talking about this today as part of an overall workplace violence prevention program, right? Because you've got harassment, it not only causes pain to the victim, but even those people that are tangentially affected within the workplace as well. It causes decreased productivity, increased turnover, certainly reputational harm. With the Me Too movement, we've seen a lot of well-known people being accused of harassment, and those organizations and the companies that they work for suffer reputational harm as a result of that, all of which not only affects the performance of the organization, the performance of the individuals, but ultimately the company's profitability and bottom line. The couple of other things that they found was, leadership and accountability are critical. This is particularly true given the fact that a lot of workplace harassment does not become reported. And so when employees feel that the senior leaders in their organization are taking this seriously and that they are going to create a workplace culture that absolutely prevents harassment, they're going to feel comfortable bringing it forward if they see something, or if they experience something, or they are part of something within a larger workplace unit. And so feeling like the senior leaders take it seriously, that there are accountability systems in place that will hold those people responsible who are engaging in harassment, and that those who report harassment are rewarded and incentivized to do so in order to create this strong workplace culture free of harassment. And the final thing that they found too is that the training must change. For many, many years, employers conducted workplace harassment training either online, some of it was done by video, sometimes they brought people in to conduct harassment training, and a lot of it was very focused on the legal liability issues of what is harassment, what is not harassment, what does the law say about harassment, and how can you avoid a finding of harassment. And what the EEOC is encouraging employers to do now is really create a stronger holistic training session that is more about civility and more about diversity and more about respect and dignity in the workplace than it is about what is and is not a legal definition of harassment. We've also seen a lot more of these trainings be expanded into addressing bystander harassment, bystander training, so that someone can feel comfortable and they know what to do and have some steps to implement if they see something that doesn't directly affect them, how they can step in and be an ally for those coworkers that may be uncomfortable raising an issue of harassment or uncomfortable workplace comments or jokes or things of that nature. So really what we're starting to see, and I think one of the things that Lindsay and I have been doing more with our clients and the trainings that we provide is doing this holistic system so that it's more engaging. You're doing more role playing, a lot more question based. So it's meant to be interactive and less of a, here's what we have to do, check the box so that we can say we've met, what we need to do for a legal defense against a claim of harassment. A couple of other things that I want, to be clear in terms of, what your duty is as an employer to your employees and to third parties who may, visit your site. Generally, there is no duty to control the conduct of another person absent a special relationship. But that special relationship can exist in the employment context because you have your employees who you have designated acting as an agent for one reason or another. Often those are managers. They could be other employees that you have said, here's your job duties. I'm telling you, you can do these things for me to benefit the company. And as a result, you as the employer then are authorizing that behavior. As long as those duties are within the scope, oh, can you go back? Yeah, thank you. As long as, no, Lindsay, if you could go back to the prior slide. Yeah. As long as those duties are within the scope of that person's employment, then you have the duty to control them. But if they're outside the scope of those duties, which most workplace violence issues are, I mean, can't think of a single employer that's going to authorize or want an employee to act, engage in a violent act. That's outside the scope of employment, and you wouldn't have necessarily responsibility for that. As long as it's in the scope of the employment, that's where you may incur what's called vicarious liability for the acts of your employees within the scope of their employment. And that's a big discussion over when someone acts, are they doing it within their job description, or is it something that falls outside the scope of their employment? So as I mentioned earlier, there's a third-party claim of negligent hiring, right? So the argument here is that the employer breached the duty to protect their employees and third parties from injuries because they hired someone who should have known posed a risk of harm and was unfit for the job. I talked about that a little bit in a prior slide. So these are often issues of, I didn't properly conduct a background check. I didn't contact prior employers to find out whether this person would be a good fit for our job. I didn't check references that were listed on the employment application or on the employee's resume, or I didn't do a criminal background check where if I had done so, it would have revealed a propensity for violence. And that's where these claims come to be. So it's really important to make a strategic decision. If you're going to do background checks, make sure you do them thoroughly, make sure you do them accurately, make sure you do them legally in compliance with the federal laws that govern and state laws that govern background checks, but make sure you're looking at them to identify potential propensity for violence and then take steps if that comes out later. As I mentioned as well, we've got the third-party negligent supervision and retention claims. This is really, once you've got an employee who's already working there, are you failing to exercise reasonable care in supervising an employee who threatens or exhibits violence conduct? So are you addressing complaints? Are you using the complaint procedure? Are you addressing through performance measures? Are you escalating concerns when you hear it? And if you didn't, was your negligent approximate cause of that harm? And that's, as I said, that's playing out right now in the Virginia civil case that has already been raised against Walmart, and that's exactly what they're claiming, that Walmart knew or should have known that this individual was making strange comments, was making allegations that potentially could be viewed as threatening, and they didn't take appropriate action. And as a result, harm resulted, and the employer should be held liable for that under a negligent supervision and retention claim. I've already talked a lot about background checks. I mentioned that there are limitations in state law. In particular, most of the time you need to do it after a conditional offer of an employment. If you do conduct a background check, you should only be looking at convictions and not arrests. That's something that you want to make sure your background check provider is looking only at convictions, generally because of the EEOC has found that there's a disparate impact on minorities, that they tend to be have more arrests than actual convictions, and so it has a disparate impact on one race over another, and therefore the EEOC is required that employers should only look at convictions. Generally, only looking back about 7 years is my recommendation, and you want to make sure you're looking at all the states that the applicant has lived in, not just the current state. The FCRA, that is the federal law that regulates background checks. So if you have a third-party agency who is doing the background check rather than you yourself, you need to make sure you're complying with the FCRA. I've talked about the ban-the-box state laws that generally is not doing a background check until after conditional offer of employment. Certainly verifications is important, making sure that people are attesting that what they're putting on that employment application is true and accurate. And you can take action in the future if you find something out that is not accurate. In the background check process, you really want to ask for details about job changes on the applications. Any negative information obtained in a background check, you want to get full information and details from the applicant. and have your HR team document everything they do, everything that's said and everything that's done, including if you're checking references and a prior employer decides that they don't want to provide a reference or only provides salary, date, won't answer the question whether they're eligible for rehire. You want to really delve deep into some of those things that may seem fishy and document it so that you can establish how this process was thorough. I do have some clients that do supplemental background checks during employment. And if you're going to do that, you want to be mindful of really probably doing it across the board or for certain job classifications, not selected individuals, so there might not be a disparate impact. So with that, I'm going to turn it over to Terry to close our session and talk about some recommendations and strategies for your workplace.
Hey, thanks so much. What I'm going to do, because we have maybe 15 minutes here to talk, I'm really going to hit some of the highlights that I think are important to consider as you either evaluate what you have in place now with your workplace violence prevention program, or as you start to think about building a program, a robust program. We could spend a lot of time talking about this, but I really just want to hit the highlights here. So there are a lot of myths around workplace violence. We hear them every time we see a tragic case, in the media. And so today I really want to dispel some of those myths and talk a bit about what the data tells us, what the research has shown us. There's been a healthy amount of research over the last decade or so around workplace violence prevention. The most important thing I think to recognize is that there are numerous pathways, if you will, that an individual can take and does take in furtherance of an act of violence. So there is no profile for an individual who may ultimately act out in a violent way in the workplace. But it's important, again, to remember there are numerous and various pathways that one takes. The important thing and the good news is that there are also many opportunities for us to intervene and disrupt that pathway. And often seemingly minor acts can disrupt a pathway. And we've learned that through the research and through interviews with individuals who were determined to act out violently and sometimes talk about seemingly meaningless intervention strategies that prevented their act of violence. And so the ultimate goal really is that to identify cues early on, those cues that may indicate a risk for violence, and just disrupt that trajectory. Most of these cues are more subtle than we may expect, right? And so in my experience, behaviors that we refer to in the industry as leakage are much more indicative of potential problems than direct threats in these cases. Obviously, I want to add the caveat, if we have a direct threat, we're always going to address that very aggressively. We're going to focus on that right away. But it's important also to recognize and understand that some of those more subtle cues are important indicators that there is a problem. And that's often where we want to try to intervene, and we want to intervene early. If we can move forward here, thank you. So there are a lot of ideas again around workplace violence and workplace violence prevention. But what we want to focus on, just some core foundational concepts that are important. If you do nothing else, right? We could spend a lot of time talking here, but if you go away with nothing else today, be thinking about these best practices for a robust program. You want to establish a multidisciplinary team that can address these issues, a team that would typically include human resources, legal, and security at a minimum. You want to have those protocols in place that have already been, this has already been addressed here. You want to have protocols in place for the early identification of warning signs. And then you want to have a process by which you can and employees can escalate those concerns to management and then on up to that threat assessment and threat management team as appropriate. And of course, you want to make sure that the employees have access to those reporting and those escalation mechanisms. So whether that is through policies, protocols, it doesn't have to be something that is formalized early on. If you're really just starting to build a program, as long as there is a protocol with policies to follow, that's something that we would recommend, that you start with really is just having those employees educated on early warning signs and making sure that they understand how they can escalate concerns, both anonymously and otherwise, so that those concerns make it to the people, that threat assessment and threat management team, the people who know the most about these incidents and understand how to address them. And so what are some of those early warning signs? Of course, this is an important question, and this is something that we are always asked. This list is not exhaustive, but it represents some of the warning signs and some of the pre-incident behaviors that are associated with workplace violence. We're generally looking for behaviors that represent a deviation from baseline behavior, right? Some change in baseline behavior. And I tell people, you know, one or two of these is not necessarily diagnostic, obviously. And it's also not the case that if you check off 5, then suddenly, you know, red lights should be blinking and you should be acting aggressively to try to pursue some solution. You really are looking for clusters of behaviors, and again, behaviors that represent some type of deviation often from baseline behavior. And so you certainly always want to listen to those who are around the individual. If you start to receive complaints around an individual, whether it is from a manager, coworker, or friend, then certainly that is something that needs to be addressed. Some of these indicators are obvious, such as making threats, but others are much less obvious, right? Harboring grudges, or someone who is engaging in harassment in the workplace, or maybe someone who's just experiencing emotional distress, and all of those stressors are starting to overwhelm their ability to cope. All of those indicators might suggest that the person is on a pathway that could ultimately lead to violence. And now I don't want to spend a lot of time talking about typologies because Lindsay spoke about this early on. The 4 types of workplace violence typologies designated by OSHA. But what I will say is this, it's important as you start to build a program to understand your threat landscape, right? And so depending on what it is that you're, not only the culture of your workplace, but how often you interact with, for example, the general public. Very important to recognize, because that could really change the direction of your program, because it's going to change your threat landscape. So that type 1 threat, those are threats from perpetrators who have no legitimate work relationship rather to your workplace. And so very different than the type of threat for a company that is close to pedestrian traffic, right? And all they're dealing with is are individuals who are employees and have a legitimate reason to be in that office space. That is a much easier program to put in place than a program that has all of these threats, all of these different types of threats to address. So again, I'll just say, recognize your threat environment, where the threat is coming from, as you start to build a program. And then what are you going to do to build that program? This is the general threat management life cycle. Again, we could spend 2 or 3 hours talking about this life cycle, but we're going to hit this really quickly here. You really should put protocols in place, even if, again, I mentioned earlier, if they're not formalized, to address each step in this threat management life cycle. So from collecting data, you want to collect information about an incident. If you receive a complaint, collect that information from a variety of sources as you conduct your investigation, so that you have a full picture of what's going on. You want to take that information, of course, and assess the threat. When you assess the threat, it's important to use empirical data. It's important to use that team that has some training and understands a bit about threat assessment. And coming out of that threat assessment, that team should be able to offer a level of concern through that triage process. What level of concern are we really talking about here? Because once you establish the level of concern, then you're going to put in place a threat management strategy. Sometimes the threat management strategy is just to handle this incident through the typical HR channels, right? The typical performance-based human resources channels that you have in place already. And that's okay. That is a strategy that you would use for a low-level threat, right? And then, of course, sometimes the most difficult aspect of a threat management strategy is this last piece, which is implementing and following up to ensure that that recommended strategy has been put in place and that there is a routine follow-up so that you can assess whether the strategy is working. So the collection of information, I just want to highlight, what is it that you're looking for if you have a potential concern that has been reported and you know that you want to gather more information, you need to gather more information about the situation, then what are you looking for? I have a whole list of things here that you certainly can review when you get this slide deck, but I just want to focus on a couple of things here. I think the major points that you want to focus on are grievances. Is this a person who has established a grievance? Are they angry at someone in the workplace? Do they feel as though they have been wronged in some way? Do they have access to weapons, access to aspects of the workplace that would allow them to do damage to and harm to your other employees or your facilities? Do you recognize, or is there an indication of pathway behaviors? So when we're talking about pathway behaviors, we're generally talking about behaviors that indicate there is planning in place, some type of plan that is being put in place for some act of targeted violence. And then finally, stressors. What is going on in this person's life that may be overwhelming their ability to cope in a more productive way, right? And it's really important to note that as you gather information about a potential incident, it's already been mentioned the need to maintain privacy, but certainly when we're gathering information and conducting a threat assessment, that privacy is really important so that the process itself doesn't potentially trigger the individual to act. Now, I want to hit this again. I'm going to hit these quickly just to give you an idea of what you might have in place. After you collect that information, you are going to conduct a threat assessment or a triage process, go through a triage process. And it may be that you determine that this concern is a low level concern. It's a level 1. So if you have a low level of concern, typically what we would recommend is that this is a situation that can be handled and should be handled at a site level at that particular site or office, not corporate necessarily, and it should be handled through a normal human resource process, right? So that would be level 1. Level 2, and I'm not going to go through all of these behaviors. You can read that on the screen, some of the behaviors that might indicate a level 2 concern. So here, obviously, we're going to be more concerned. We are definitely going to want to conduct further inquiry. We're going to gather some more information. We want to gather information from as many sources as we can while maintaining, of course, the privacy of that investigation. And typically a level 2 concern would still be managed at the site level, but it would be escalated to that site-based or regional-based threat management team, who would then execute that investigation and data gathering, and they would likely notify the corporate threat management team of what's going on. It's typically a notification that's still handled there at the site level. And then moving up to level 3, a level 3 concern is elevated. This is where you have some more direct concerning behavior, disruptive to the workplace, and you may be concerned about the safety of your staff or even your facility. These behaviors would typically be escalated to the corporate level threat management team. And the corporate level team would assist in the development and the coordination of a threat management strategy and would work closely with the site to ensure that that strategy is put in place. Often the corporate team would need to provide some resources to the site. This is when you may bring in outside experts for consultation on best practices and how you might address the concerns. And of course, at this level, you're really thinking about administrative leave while that investigation takes place. Maybe you're going to issue a BOLO. Maybe you're going to restrict access to the facility, and maybe even enhance security to be put in place. And then this last level, level 4, as I often say, this is where we've really lost the battle, right? When we get to level 4, this is where something has happened, violence has already occurred, And depending on your role in the organization, this is where your threat management team is really going to engage in liaison with law enforcement and monitor the situation. And then, of course, ensure that longer range, there is a plan in place to monitor the behavior and ensure that the workplace isn't subject to additional violence. So just again, some typical outcomes, something to keep in mind when we're managing these types of issues. It's good to have some guidance that allows for a structured approach to threat management, but also very important that you are able to articulate that each case is handled individually on its unique features, right? And so I like being able to structure how these levels of concern look, because it's going to guide your team. It's going to frankly give your team the confidence to handle these situations and the ability to rest at night, frankly, when you're dealing with some really concerning behavior. But it, again, is important to recognize each case is unique, each individual is unique, and there are a lot of different factors. Each case has to be handled individually. And then, of course, be mindful, as I've already mentioned, that some of those management strategies or interactions can be deemed adversarial with the person of interest or with the employee, and that alone could serve as a trigger and initiate mobilization to violence. So that's why we really like that multidisciplinary team approach, because everyone weighs in and everyone may be needed to really put that plan in place, a plan in place that's going to prevent additional exposure to the workplace. And then visibility. It's important also to remember that you want to have, to the extent you can, visibility into that individual's future behavior and mindset, because the threat assessment and the threat management doesn't stop when the person is terminated and they're sent home. We all know this intuitively, but I always feel like I have to talk about it, because so often the cases that we are called in to assist with are those cases where an individual is terminated and then the threat actually is increased or is elevated post-termination. And Lindsay, I think I'm gonna, if you can just advance past this one, these are just some trends that we're seeing, and I just wanna hit this last slide and wrap it up here. I like to end with just kind of a summary slide. After all that we've talked about, the bottom line is have a program in place that is effective and that is defensible, right? These programs can look very different based on the culture of your organization. Make sure it's effective, make sure it's defensible, make sure that at a minimum you have, if you have a workplace violence prevention policy, then have a mechanism by which employees can recognize concerning behavior and they understand how to escalate it to a threat management team, and a threat management team that understands through training how to handle these incidents in a way that is best for your organization and can reasonably ensure the safety of employees.
Thank you so much, ladies. So just going off of the slide that you just had, where should companies look to start their harassment training program? Especially like particularly smaller companies looking for a program to introduce to their employees.
So where you should start on a workplace violence prevention program, I would say the first thing to do is identify those key stakeholders who are going to be responsible for addressing concerns. I think that's foundationally, that is the best thing to have in place. And typically it's going to be human resources, it's going to be security, it's going to be legal at a minimum. And then start building from there. Then start thinking about that policy, putting a policy in place, talk about and think about how you're going to train your managers and your workforce so that they have those reporting channels. And typically that training would start with onboarding. At the onboarding process, then that's the easiest way to educate employees as to the escalation mechanism that you have in place. And then once you grow, then we recommend annually you're going to give a refresh on that training. For all of your employees, it doesn't have to be this long 2-hour training. For the whole workforce, we're recommending like 30 minutes. This is what you want to do if you have concerns.
Mm.
And I think that's where I would start.
I would just add OSHA, I think I said this during the presentation, but OSHA does have sort of a general workplace violence resource page. So OSHA.gov, you can go there, search workplace violence, and they have, they go through some background information, but they also, I believe, have like sample programs and policies, as well as sort of just general guidance on what sorts of things are effective in those types of programs.
So what are the steps to reporting violence when there's no visible HR department in that small company?
Yeah, I'll jump in. You'd want to report it to really any manager, right? You want to make sure that management is aware, and that, they, even if a small company and you don't have designated HR departments, you want to report it to the person who's really in charge of, like, whether it's the general manager or whether it's the plant manager, the person that is generally in charge of operations at that site.
Great. And last questions. On one of the slides, it says 80% of the violence is in education and healthcare. As a former teacher, I'm just interested in knowing, like, what part of education? Is it elementary? Is it in higher ed? Do you know the statistics for that?
I don't know the specific breakdown. I would say that of that 80%, a majority is definitely health side. I think it's just sort of how BLS tends to group these things together.
Okay.
But I will say that a majority of that number is the healthcare services piece.
All right. Well, thank you so much. So on behalf of AWCI, we would like to thank, again, Kara, Lindsay, and Terry for this much needed presentation. And we would like to thank all of our attendees for joining us for today's webinar. Stay well and safe. And until next time, have a good day, everyone.
Thank you.
Bye.
Thank you.
Thank you.